Okay, now I'm really done, and over to Christopher for our presentation of the day.
Hello, everybody. Thank you so much for the introduction. Hope you're all doing well. Obviously, we're here today to discuss one of my favorite topics, covenant enforcement in community associations, which I'm sure for a lot of you CAMs and board members, this is something that you deal with daily, as do I. I will say in the last 2 weeks, I've probably sent out more than 15 letters to communities, to residents, to tenants saying, hey, you're breaking the rules. So I know this is an important topic. And let's jump right in. I guess real quick, obviously this is me right. Oh, I need to share my screen. Totally missed that part. Here we go. So obviously this is me many years ago. I've been with KBR for about a year now. Been practicing for about 8 years, doing various things like community association law of all kinds, things to litigation, collections, covenant enforcement, like we're going to talk about today, and just general counsel, helping associations with their day-to-days. So let's just jump right into the meat and potatoes. Obviously, we are here about covenant enforcement for both HOAs and condominiums. Now, for the most part, it's the same, regardless of whether you're in an HOA or a condominium. But at the end of the day here, we're talking about these covenants. So covenants are essentially promises or rules, so to speak, that anybody who lives within your community has to follow. Things like tenant restrictions, rules where you can walk your dogs, trash days, maintenance obligations, basically anything that requires someone to take or not take certain actions is a covenant that should be listed in your governing documents or your rules and regulations. Now, I will say a lot of this stuff I'll be talking about today is applicable to all communities, but at the end of the day here, it's important to know what your governing documents have. So while again, there might be things of general applicability, I always ask you to refer to your own legal counsel and your documents to determine whether these things are applicable to you or are different. So again, these covenants and rules, it is your responsibility as board members and CAMs to make sure that everybody is playing by the same rules and following them. In fact, you have, as board members, a fiduciary duty to enforce these restrictions. Because if you fail to do them, if you fail to enforce them uniformly, you fail to enforce them entirely, or you sit on your hands and wait to enforce things, well, you might find that down the road when you really want to enforce something, well, you might not be able to. So again, some examples of these covenants are things like alteration standards, ARC, architectural control committees, dealing with things like house colors or things that you can put in front of your yard, things like age restrictions. So some of you may be living in 55 and up communities. It's your job as board members to ensure that you are making sure that the community is abiding by the 55 and up restrictions. Pet restrictions, like I mentioned before, restrictions on leasing and sales, things like having approval requirements, having tenants submit an application before moving into a unit, things like guest occupancy restrictions, whether guests are permitted to stay within the condominium for a certain period of time without the owner, and finally, nuisance conduct. Well, nuisance is kind of like a catch-all thing that we use when there really isn't something to pin it to a certain restriction. But the long and short of it is a nuisance is something that either impacts the safety, the insurance, or just the general enjoyment and use of the property. So if someone's being loud at 2 o'clock in the morning, being a bit too rowdy, well, that's a nuisance violation because it impacts the rest of the community. So for both HOAs and condos, really the first step, which shouldn't be surprising, is to put someone on notice that they are in violation of those documents. So what I mean by this is sending a first notice to the resident or tenant, giving them an idea of what the violation is and what they need to do to cure that violation, as well as a deadline in which they need to do it. These are generally informal notifications from a management company or the board of directors saying like, hey, Joe, you let your dog, out without a leash, according to article blah, blah, blah. All dogs need to be on a leash while walked outside of a unit. Don't do it again, that kind of thing. Of course, if Joe doesn't comply, well, then the next step is a bit more formal. So when you're going to enforce, let's say they don't comply, the association has a couple tools in its belt, so to speak, that it can use to achieve compliance. These are things like assessment of fines to, if you need to, actual legal action to ensure compliance. Obviously, filing a lawsuit over someone not walking their dog properly might seem petty or unreasonable, but at the end of the day here, if someone doesn't walk their dog with a leash, I mean, there's potential liability for the association if the dog gets out and attacks someone. At the end of the day here, we're trying to make sure everybody plays by the same rules. And again, as I said earlier, if we don't go all the way to enforce these things, well, we might not be able to enforce them at all. So going back to fines, we're going to start with HOAs first. HOAs have the authority to assess fines against owners, even if the governing documents of the association are silent. It's baked into the statute, allowing associations to levy these fines. Now, fines against an owner are capped at $100 per violation or per day that the violation continues, up to $1,000 in the aggregate. So basically, if a violation is $100 per day and it goes on for more than 10 days, it doesn't matter. You're capped at $1,000. Now, unique to HOAs is the ability to increase this cap if your governing documents allow for this. So if again, you should check your declaration for this. If it says, fines can be $500 per day up to $5,000 in the aggregate, well, HOAs are able to do that. Not so much for condos, but I'll get to that later. So another thing that these fines can do is on their own, they're really just a charge on the owner's account, which they may never pay. It's likely that if it is going to be paid, it'll be paid at closing or when it comes to bite the owner back later down the line, which I will get to later, so spoilers. So HOAs do have the authority to turn these fines into liens if they're more than $1,000. However, it needs to be in your declaration that the board can do this. So if your declaration is silent as to fines becoming a lien, you very likely cannot turn that fine into a lien. Now, if it is in your declaration that you can do this, and your board goes through the steps to turn that fine into a special assessment, it means that if the owner does not pay, it can eventually go to foreclosure and someone can lose their house over these things, which again, it might seem excessive, but really at the end of the day here, the associations are given these tools to make sure everybody is playing by the rules. You live in these communities with the understanding that everybody will play nice, so to speak. And obviously, as we know in practice, that's not the case. So these fines are one avenue that associations can use to hopefully achieve compliance from owners. Now, there is a certain process that has to be followed, and it's important that you work with management or your legal counsel to really nail down this process. Now, after this first informal notice is sent, let's say the violation continues. Joe is continuing to let his dog out without his leash. Well, the next step is to send a formal notice letting Joe know that, hey, your violation is continued. Because of this, the board has voted to proceed with a fine against your property, and you have an opportunity to attend a hearing in front of what's known as a grievance committee, and then there's a date listed. Now, this date can't be less than 14 days from the date of the letter, and it also can't be more than 90 days from the date of the letter. So you can't wait. You can't push off the grievance committee hearing far in advance. You really want to get to it as soon as possible, but you obviously have to give them more than 2 weeks notice to either cure or gather, I guess, their own evidence to bring up with the committee. Now, this formal notice has to be specific. It has to clearly state what the violation is. It has to state what they need to do to cure it. Ideally, it'll also state or cite to the proper article or rule in the governing documents that states that this is a violation. It'll also say like, hey, this is how you can attend the grievance committee. It might be by Zoom, might be in person. Either way, if it's by Zoom, it'll have the Zoom information, by phone, telephone number, and if it's in person, should have the address of the grievance committee hearing. Now,
Chris, I'm going to interrupt so you can have a quick water break. Folks, I'm getting a lot of people in the Q&A. You will be able to get the slides later. For those of you joining us, you don't have to take copious notes. You fill out the required evaluation at the end, and then you'll be able to click on the link after you fill out and submit the evaluation. There'll be a link to download and save the slides. So please keep that in mind. And another question coming up constantly here. This is one of those courses also valid for HOA board members, continuing education credit units. You will get 1 CEU if you are a board member, and as well if you are a manager. The certificates will be emailed to everybody to the addresses you used when you registered within 7 business days from the end of this class. Chris, pardon the interruption. Back to you.
Good. That's all very important. So make sure you fill out those forms so we can make sure you get your certificates. So going back to the grievance committee that I was talking about, again, this is also important because a lot of these steps, if they are missed, You're giving someone kind of a way in to challenge a fine, and you don't want to be in front of a judge and discover, uh-oh, we did something wrong. So this grievance committee, and I find that this is probably the hardest step for a lot of associations. So this committee has to be comprised of at least 3 individuals. They have to be residents. They can't be officers, directors, or employees of the association, or a family member of those individuals. So no spouse, parent, child, brother, or sister of an officer, director, or employee. So it's kind of, like I said, it's very hard to do this. We tend to find that people don't really want to serve on these committees because you are becoming the face of rule enforcement. But it is a very important job. And again, if you don't have this grievance committee in place, you no longer have the ability to fine. A board can't just vote at a meeting to put a fine on someone's lot. They have to go through this grievance committee process. Now, once this notice is, the formal notice is sent to John saying, hey, the grievance committee hearing is going to happen October 1st. At that hearing, John will meet in front of the grievance committee. And this grievance committee's sole job is to approve or reject whatever fine is levied by the board. So the board at a board meeting would say, hey, John's been doing this. We've noticed 10 situations where he's walked his dog without a leash. We're going to levy a $1,000 fine and push us to the grievance committee. That formal notice is sent. John shows up to give his side of the story. Although I can't really think of too many ways to justify walking your dog without a leash. Doesn't matter how good of a boy your dog is. You got to have a leash on your animal because again, they're animals. You don't know what they're going to do. So again, this grievance committee will take in that testimony from John, maybe from the board, and then their sole job is to either approve or reject that fine. They can't modify it. They can't say, oh, $1,000 is too much. We're not going to give anything. Their sole job is say yes, $1,000 or no fine. And obviously it has to be approved by a majority of the committee. So that's why you need at least 3. So if 2 people vote in favor of the fine going forward, it will go forward. Now, within 7 days of that hearing, the committee must provide a letter to John. And this should, like any notice that an association sends out, it should go to the property address, and if the association has an alternative mailing address on file, should also go there as well. This notice should state essentially, hey, the grievance committee has approved the fine to go forward in the amount of X dollars for your violation. Should also, again, restate what the violation is, how it can be cured, and the date in which the fine must be paid. Now, for HOAs under the new legislation, that happened last year, this deadline to pay the fine can't be less than 30 days from the grievance committee notice. Now, let's say John gets rid of the dog or, puts in writing or takes certain steps to cure the violation to the satisfaction of the board within the notice periods provided under those letters, the fine can't be imposed. So let's say that formal letter goes out saying, hey, the hearing's going to happen October 1st. And let's say the violation is something that's a bit more easily cured. Let's say John had an impermissible chair swing on his front yard. He didn't get approval for it. He gets this notice saying it has to be removed, or the hearing will go forward October 1st. Let's say middle of September, he has it removed. No violation is present. At that point, the committee hearing will not go forward and a fine cannot be assessed. Now, obviously, if the fine is assessed by the committee and it's not cured, and if it's not paid by that 30-day deadline, well, that fine will then become a charge on that unit owner's ledger. Additionally, I know associations tend to speak with their attorneys to get advice, figure out how to proceed with things. Attorneys' fees and costs cannot be chargeable against the owner or recoverable against the owner unless this process is properly followed. So let's say you have a meeting with your attorney prior to this grievance committee date. Those amounts are not chargeable to the owner. It's everything that happens after the fine is set, so after that 30-day period, that the attorney fees and costs can begin to accrue. So it's important that you really finalize your enforcement policy, have everything in place with your attorney. That way you don't need to keep consulting with your attorney to deal with enforcement issues unless they're really bad or if fining doesn't work. Or obviously if you don't have a grievance committee, well, then you need to go to your attorney anyway to proceed with more formal enforcement. Now, again, if the grievance committee meets and they say, you know what, we're not going to charge the fine for whatever reason, and they reject it, obviously that fine does not continue. If the board wants to proceed again, they got to start all over from the beginning. Now, part of the new laws that came out last year restricted certain things that the association used to enforce. Things like leaving garbage cans out beyond the kind of allotted garbage can dates. Like a very common rule is saying that garbage cans can only be put out 24 hours, there's been 24 hours, excuse me, of the garbage collection time. So let's say it's Wednesday, garbage cans are only allowed Tuesday through Thursday, essentially. Obviously Wednesday, because that's the date the garbage will be collected. Well, the legislature found that was a bit too strict, and now associations can't enforce that. So if you have a restriction in place saying the 24-hour limit, that's no longer enforceable. Obviously, if they leave it out there for weeks and weeks and weeks, or be like, let's say, 72 hours beyond the garbage collection date, well, then enforcement's a bit more, enforcement is allowed. By the same token, the legislature also found that I guess they like to keep their holiday lights up longer, because rules saying, oh, you have to keep your holiday lights out, or you have to remove them within a week of a holiday, as an example, again, are also no longer enforceable. To properly enforce the holiday light restrictions, you have to first send a notice, let's say a community notice saying to everybody saying, hey, you need to remove your holiday lights within 2 weeks of the holiday. If someone then, the 2 weeks pass, someone still hasn't taken their holiday lights down, then you begin with that first direct informal notice saying, hey, you are in violation, and we'll proceed with enforcement. I tend to find that when these kinds of legislations added, it's because somebody who makes the rules received a violation letter and said, this is ridiculous, and they changed the law. Now, moving on to condominiums, a lot of this is the same for condominiums as well. So authority to fine, just like HOAs, is baked into the statute. So if your governing documents are silent, you can still proceed with fining. Again, same $100 per day or $1,000 in the aggregate cap is in the statute. However, there is no authority for a condominium to increase those limits. So if your governing documents say, oh, fines can be $500 per day or $5,000 in the aggregate, that is not a valid restriction. That is not a valid provision. You are capped at the $100 per day and $1,000 in the aggregate. Additionally, fines can never become a lien in a condominium context. So even if let's say someone has 3 violations that have been going on, they get fined, $1,000 for the 3 different violations, so $3,000 in fines. Doesn't matter what your documents say, that could never become a lien on the property, meaning it would never go to foreclosure just for those fines. Additionally, another change, and again, I guess let me back up. You still need to send that informal notice, followed by the formal notice, putting the owner and tenant on notice of the violation, what restriction they're violating, how they can cure it, and when the grievance committee will meet. However, one minor change is if the committee approves that fine, instead of within 7 days, the committee should send out the notice right away, and that fine is due within 5 days of the owner or tenant's receipt of that fining notice. So if the grievance committee approves the fine, they send a letter to John at the condo saying, hey, if the grievance committee has approved your fine because you left trash in the hallway, you have 5 days to pay a $1,000 fine, or it'll become a charge on your unit. And again, as I said earlier, with any notice from the association, it should go to the actual unit address or home, as well as any alternative mailing address on file. Now, in addition to fines, boards also have the authority to suspend use and voting rights. So if you find that fines are not working the way, you're not achieving compliance, you can also suspend someone's use and voting rights. It's the same exact process for a fine. You give them that informal notice, then the formal notice. The board then approves proceeding with a fine, or in this case, a suspension, goes to the grievance committee, and they can either approve the suspension or reject it. Now, important to note for suspensions, this is probably a bit more common for condominiums, but you cannot suspend someone's right to use access points to the community, so to speak. So you can't say, oh, you're suspended from using the common elements, so you can't use the elevator, you can't use the stairs, you can't park in the parking lot. You can't do those things. You cannot prevent someone from gaining access to their unit. This is more so, let's say your community has a country club, tennis courts, pools, those kind of amenities. You can stop someone from using those. Now, it's important to note that obviously if your community has just open amenities or owners are given keys, it's a bit harder to enforce that. So if you have, let's say, like electrical locks or something, and you can lock out someone after you properly suspend their use rights, it's a bit easier to enforce in that case. Same thing with voting rights. Similar to if someone's delinquent for more than 90 days, you can suspend someone's voting rights. However, again, it's the same exact process, and there must be at least $1,000 in fines to allow the voting rights to be suspended. In 2017, the legislature updated 718 to require that this fine has to be at least $1,000, and you must provide at least 30 days notice before proceeding with suspending the voting rights. Additionally, if there is an election within 90 days, or if an election is happening within 90 days, or at least 90 days before the election, an association must provide notice to every resident whose voting rights might be suspended, that put them on notice that, hey, your voting rights could be suspended because of your violations or because you are delinquent in your assessments. Anybody whose voting rights are suspended are essentially removed from the calculation for quorum and voting purposes. So, like fines, to take effect, written notice of the suspension must be delivered by mail or hand delivery to the actual property address and to any alternative mailing address the association has on file. And with voting rights, again, that individual is kind of removed from the calculation. So if you needed 20 people to show up at a meeting to have quorum or to approve a vote, you need 19 now. So again, in addition to fines, the board has the right to suspend use rights. And again, like I said before, you cannot suspend someone's access to a unit. So obviously you can't prevent them from parking within the community. You can't prevent them from using a security guard gate. It's really just for amenities. So if your community doesn't have any amenities or anything really worth suspending over, you might want to just consider proceeding with fines, voting rights suspensions, or if those don't work, sending it to your attorney to proceed with further action. And again, like fines, the grievance committee has to approve these for them to take effect. So let's say fining doesn't work. Or let's say you, like many other communities, struggle to put together that grievance committee. So what do? Well, you turn it over to your legal counsel. So as I said earlier, if you don't enforce these things, you might lose your ability to enforce them. So it is important that if you can't fine, well, then you have your attorney take the next steps. And generally that means sending a bit more threatening formal letter to the owner to get compliance with a threat of legal action if they don't come into compliance. And the next step, if the legal attorney letter doesn't work, is to send what's known as a pre-suit mediation demand. Now, for those who haven't been to mediation, mediation is essentially two parties, generally the association and an owner, and a third party mediator who is an unbiased neutral party who is there to try to create a dialogue between the two parties to try to reach a resolution. Now, associations are required to do this process because the legislature has found that in the past, associations would just start suing people. And because associations tend to have a bit more resources than the owners, it was really unfair to the owners who were having to deal with all these lawsuits. So this pre-suit mediation process is required in order for an association or even an owner to recover their attorney's fees and costs should they prevail in a lawsuit that happens afterwards. If they don't do this mediation step, their case could even be dismissed, or if it goes forward, they would not be able to recover their attorney's fees and costs even if they prevailed. So it's very important that this step is followed. Now, this pre-suit mediation step is only required for certain disputes, that being uses or changes to parcels or common areas, things like amendments to the association documents, that being like an amendment was not passed correctly, issues regarding meetings of the board and committees appointed by the board, membership meetings, not including election meetings, because elections are treated in a different fashion, things like access to association official records, and like what we're doing now, covenant enforcement. So really, if someone's breaking the rules, after the formal enforcement fails, you then proceed with a pre-suit mediation demand. And this is both for HOAs and condominiums. I know it says HOAs here, but it's for both. Now, certain things are not subject to this pre-suit mediation requirement, meaning you send that formal notice, and then you just go straight to a lawsuit. There's a bit of variance because for the first one here, we have collection of assessments. There is a statutory process that needs to be followed in order to properly collect assessments, but that doesn't have to go to mediation first. There's just your first notice, and then a lien, and then other notices. An action to enforce prior mediated settlement agreements. So if we've already went to mediation on something, and let's say we got an owner to agree to stop doing something in writing, well, if that owner suddenly violates that agreement, we don't have to go back to mediation. We just leapfrog right into court. Actions for evictions or removal of tenants. Certain documents might allow an association to step into the shoes of a landlord and immediately proceed with the eviction of a tenant. You do not have to go to mediation in those cases. However, if your documents don't give you that authority and you are trying to get an owner to kick out their tenant, you would need to go to mediation for that. Things like an alleged breach of fiduciary duties aren't subject to pre-suit mediation. That being claims that a board member is not doing their job, essentially, not required to go to mediation. Things like recall and election disputes require arbitration with the Division of Florida Condominiums. And finally, disputes between parcel owners are not really the obligation of the association to deal with. So if two owners are fighting over something and it's not impacting the rest of the community, or it's not really a violation, the association doesn't have to get involved, and that's also not subject to the pre-suit mediation requirement. Obviously, if it's a kind of a two owners and the association being involved, well, then that might change things. It's pretty fact specific, so I urge you to speak with your counsel to see if that's the next step that's required after the association counsel gets involved. Same thing, condominiums also have this pre-suit mediation requirement, and they have their own list of disputes as well, some with some overlap. This includes things like the authority of the board to take certain actions, or actions to require an owner to do or not do something. This is generally covenant enforcement things. Let's say like an owner has that chair swing in their front yard, they don't take it out. That would be subject to pre-suit mediation before an association can file suit to have a judge enter an order to require that individual to remove that chair swing. Which I guess I skipped ahead because that's also altering common elements. Let's say an owner puts their swing on the public park within the community. Again, if they don't take it down, could be subject to pre-suit mediation. Other things could also the failure of the board when required by law or the association documents to take certain things. So let's say the documents say the board has to hold a certain number of meetings or have to conduct elections in a certain way. That can go to mediation. If the board fails to give proper notice for a meeting, it can go to pre-suit mediation to properly conduct a meeting or to allow inspection of the official records of the association. So if you give a request to your board saying, hey, I want to look at, the contracts of the association from the last 2 years, if they fail to do that, obviously you can do a complaint with the DBPR, or you could send a pre-suit mediation demand. Just like there are disputes subject to pre-suit mediation, there are disputes that are not subject to pre-suit mediation, things like title to a unit. So if you have in your documents that a purchase has to be approved in order to be valid, that would just be a lawsuit. You don't need to do pre-suit mediation in that case. Assessments, again, like I said, there's a statutory process that you need to follow to collect those assessments. Again, if your docs allow you to evict the tenant directly, you don't need to go to mediation. And breaches for fiduciary duty or claims for damages based on the association's failure to repair or maintain common elements or units. Now, obviously, as I mentioned earlier, certain things that are not subject to pre-suit mediation are subject to what's known as mandatory arbitration. This is with the Division of Florida Condominiums, Timeshares, and Mobile Homes up in Tallahassee. These are primarily things dealing with recall and election disputes, as well as those certain disputes. Oh, well, and the disputes between owners, again, that's not arbitration or mediation. That's just a lawsuit and maybe a stern talking to two owners who can't get along. Now, the definition of dispute is being expanded, although it hasn't taken effect yet, but it's important to keep in mind because a lot of these things I'm about to talk about are very relevant to many condominiums. This disputes term, which is going to be updated in July of next year, of 2027, so 2 years, will include the failure of the board to obtain a milestone inspection, which I'm sure a lot of you hopefully have done already, failure to obtain a structural integrity reserve study, or your SIRS, failure to fund those reserves, and the failure to make or provide necessary maintenance or repairs of the condominium property as recommended by that inspection report or the structural integrity reserve study. Those are not subject to arbitration. That is just mediation into a lawsuit. Now, this pre-suit mediation demand, it's very important that you follow the requirements of the statute. There is a kind of a template, so to speak, included in the statute that must be substantially followed. This letter has to be sent by certified and regular mail, again, to the property address and to any alternative mailing address the association has on file. It must also list or recommend 5 mediators and give their information, things like their hourly rates, their location, and their phone number or their contact information, and has to give the recipient of that letter, generally in this case, a homeowner or condo owner, 20 days to respond to the pre-suit mediation demand by agreeing to one of the mediators, suggesting their own mediator, and essentially just agreeing to mediate. Now, if the owner responds and agrees in writing to go to mediation, the parties have 90 days in which to have that mediation occur. That time period can be extended if the parties both agree, but generally speaking, you have 90 days from the date the approval is received to get that mediation scheduled and going. Now, if no response is received, let's say the owner either rejects going to mediation or just doesn't respond, well, the association no longer has the requirement to go to mediation. It can just go right into the lawsuit and it has satisfied that requirement. And again, let's say the owner doesn't respond to the mediation letter. Well, if the owner prevails in court, they won't be able to recover their attorney's fees and costs from the association. So both sides, it is imperative that if you receive a pre-suit mediation demand either from an owner or from the association itself, you should respond to it and agree to go to mediation so that if you do have to sue or are sued later, if you prevail, you basically save your right to get attorney's fees and costs. Now, at this mediation, if a settlement is reached, fantastic, maybe we're done, and peace is restored. If no settlement is reached, the mediator might declare what's known as an impasse, and they will issue a report saying, hey, no settlement was reached. If that occurs, either party is free to proceed to a lawsuit.
Chris, is RRR report review repair?
Say again?
RRR is report review repair?
That is, I actually don't know what that stands for, but it is regular mail. Oh, return receipt. No, sorry, return receipt requested.
There you go.
Certified
Okay.
mail.
I just wanted to clarify because in our world that also stands for report review repair and for the few people in the Q&A. So back to you, sir. Thank you.
Hey, no worries. Hey, look, kind of quick sidebar on this. If you see violations occurring in your community, you should report them to your board so that they can be properly enforced. So this arbitration process. So obviously for those disputes that are not subject to pre-suit mediation and things like election recall disputes, which are required to go to mandatory arbitration, there is a required notice that must be sent. If this notice is sent, and the notice should state the intent to file arbitration if something is not cured, if that time period passes, that person can then proceed with filing their arbitration complaint with the division. There's a special form that needs to be filed along with a $50 filing fee. Once received by the division, they will assign an arbitrator to it who will do a brief investigation to determine if they have jurisdiction, if notice is properly sent, and if they receive that $50 filing fee. If they do have jurisdiction, the arbitrator will do a follow-up investigation and determine, we don't have jurisdiction. They'll let the people know, hey, this has been dismissed, go about your business. If they find they have jurisdiction and the filing fee was paid, the arbitrator will then provide both parties with 20 days, the respondent of the petition, so whoever's the complaint is being filed against, 20 days in which to file an answer to the petition. Now, once the answers are in, the arbitrator will review them, and if there is no material fact, if it's clear what the answer is, the arbitrator might issue a final order. So if there's basically the facts are obvious or there's no defense that could be raised, the arbitrator will issue a final order, which can include fines as well as attorney's fees and cost awards. Instead, if there is some dispute or confusion or it's not clear what the answer is, the arbitrator might require both parties to attend a final hearing, which is the same formalities as essentially a court hearing. And within 45 days of that hearing date, the arbitrator has to issue a final order. For those attorneys out there, I'm sure you've dealt with this where you'll have a final hearing in front of a judge and months later you have no answer. Well, arbitrators have to provide this final order within 45 days of that final hearing. Now, if a party is unhappy with the order, which there usually is, they have the option of challenging that order by filing a trial de novo in court, an appeal in court, but it has to be done within 30 days of that order being issued. In the same token, if the other side is not following the enforced order, they can seek enforcement in court as well. And like I said earlier, attorney's fees and costs can be awarded by the arbitrator. Now, who can file claims? Well, pretty much anybody. An association can bring suit against an owner, a resident, a tenant, a guest, anybody, really. Although, for the most part, it's going to be against an owner because, as I'm sure you're all aware, it's ultimately the owner's responsibility to police their guests, their tenants, their family, vendors that come on their property, contractors, so on and so forth. And they're the ones who the fines are going to be levied against. You can't really fine a guest. I mean, I don't know about you, but if I received a letter in the mail saying an association I went to fined me $100, I probably wouldn't pay it. But it'll most likely be going to the owner because they're the one who actually live in the property. And depending on what your documents say, might be subject to a lien if they're named an HOA. By the same token, a unit owner can file suit against the association, either on behalf of themselves, their tenants, guests, or their vendors. Now, a tenant can also file a suit, and guests can as well. So really, they can come from anywhere. But at the end of the day here, it's most likely going to be an association against an owner or an owner against the association. Now, self-help. So in recent years, courts have found that, oh, I guess let me back up. So when it comes to filing the lawsuit against owners for covenant enforcement matters, generally speaking, the goal of an association is to obtain what's known as injunctive relief. This is essentially telling the court, judge, there is nothing we can do to get this owner to bring their unit into compliance. We need your help to enter an order, putting real penalties on them if they don't comply. Now, injunctive relief orders can come with penalties such as additional fines to things like even jail time. I never thought I would do this. I'm not a criminal attorney. I've never been a criminal attorney, but even I, through an injunction, have put someone in prison because they failed to comply with the judge's order, and that was for a covenant enforcement matter. However, one key part of injunctive relief is you have to demonstrate to the court that you have no other remedy but asking the court for help. Now, in recent years, courts have found that associations oftentimes have an available remedy, even when it doesn't seem to be obvious. That is this self-help. So many of your documents, and again, if you're not clear on this, I highly recommend you speak to your own counsel, will have this self-help language. This might come in the form of if a unit owner or owner fails to maintain their lot or unit, the association has the right to go onto the lot and do those necessary repairs or actions to bring the unit or home into compliance. So going back to my previous example, let's say John has that swing set out there. If the association documents have that authority to go onto a lot and bring a unit into compliance, the association has to attempt that first before they can proceed to filing a lawsuit. Now, I'm sure many of you are thinking, well, what if this owner's known to be aggressive or has threatened people in the past? Well, unfortunately, there was a case where the association said, hey, this guy is hostile. We don't feel safe sending our property manager out there to address these violations. Unfortunately, that is not enough. A risk of harm is not the same as actual harm. So if someone is making threats, you still have to make an attempt. But if someone comes out, with a weapon, you make sure you document that completely, and then you discuss with your legal counsel and determine if that's enough to maybe avoid the self-help requirement. But again, just the threat of harm or perceived harm is not enough. There needs to be actual evidence that harm could occur or has occurred. And it's unfortunate that this is the case because, and I don't know what it's going to take to change the law on this, but as far as I know, no one's really been hurt yet, but it could happen where a property manager is going in to clean something up, they get injured, and that might be the wake-up call the legislature needs to really change this, to really protect people just trying to bring compliance to their community. So if you're dealing with these kind of things, where it's something that you feel like the association can go on the property and just fix right away, speak to your counsel first, or to see, one, if you have this self-help authority in your documents, and two, how you can go about proceeding with that self-help. It's also important to note that a lot of times these self-help requirements allow the association to charge the expense incurred by the association in achieving compliance against the unit owner. If your documents don't allow it, I highly recommend you speak to your legal counsel about allowing that charge to become a special assessment. Without that authority to make it a special assessment, again, it would just be on their ledger, which likely will only get paid when they go to sell the unit. Now, defenses. So as I mentioned very early on, if you don't enforce properly, you don't enforce timely, or you don't enforce uniformly, you might run the risk of, you go to mediation, you file a suit, and the owner brings a number of possible defenses against your action to weaken or destroy or defeat your claim that they were not properly following the rules. First one here is selective enforcement. So let's say, John has this swing on his front yard that he's not supposed to have, but Bob, who is a former board member, has one up as well. Joe gets the notice, he gets the fine, they did bring him to court over this, and Joe shows up in front of the judge and says, Judge, I know at least Bob and other people in the community have these swing sets, but I'm the only person who's getting targeted. That is selective enforcement. So it doesn't matter the circumstances for the most part. You need to make sure that when you're enforcing these restrictions, you enforce it against every single person. There might be exceptions. Let's say someone had a swing set and then the board updated their policies that said that swing sets are no longer allowed. So it may be grandfathered in. But absent that, you need to make sure that there's uniform enforcement throughout the entire community. There's things like estoppel. Joe might say, hey, This board member said I was allowed to have my swing set. There's no issues. Here is the letter from him saying it's okay. Why am I being sued? I relied on this letter to put up my swing set, and now they're suing me. That is not fair. Well, that's estoppel. If they can claim they relied on an assertion by somebody within the association who has the authority to make that assertion, the association might be stopped from enforcing. Another one is waiver. As I said before, it's very important that if you see a violation, you enforce it as soon as possible. If you let something sit for a long time, not only can the owner bring up the defense of waiver if you're in court, it might result in you being unable to enforce your restriction outside of court. All of these as well. If you're not uniformly enforcing, or you've told people they can do certain things, and then you turn around and try to enforce them, that rule might not be in effect anymore. One primary example I see a lot is communities that are not pet friendly. There's communities that don't allow any dogs, and let's say a new board comes in and they're pretty lax on it. They like dogs themselves, and they start letting a few dogs in here or there. Well, a couple of years go by, and a new board comes in and says, "Wait a minute, our documents say no pets. Everybody has to get rid of their pets." Well, it's almost a certainty that someone's going to raise the defense of waiver. And all of a sudden, that pet restriction in your documents has no weight. So you can't enforce. Same thing with latches. If you sit on your hands to enforce something, you might lose your right to enforce it. Again, like same thing with statute of limitations. Certain things have a certain time period in which you can bring suit. Things like contract disputes, I believe, have a 5-year statute of limitations. So if it's been more than 5 years, you're dealing with a vendor. Well, if they say statute of limitations, your case might be just done because you've waited too long. Going back to waiver, we tend to find that if something's been going on that the association knows about for more than a year, so I'll give you an example. Let's say someone has had a dog, you're a no pet community, and this person's had a dog in their home for over a year. Well, when we advise clients, we caution them that it's very likely that this owner will bring up waiver or latches to defeat the association's lawsuit. So again, it is imperative that if you see something, you enforce it. Now, unenforceable provisions / rules is a bit more complicated, but there are certain restrictions and case law on what the boards can make into rules. There are certain things that, if they're in the rules but not referenced in the declaration, it's assumed that there is no restriction. So if the declaration is silent as to a particular restriction, you can't just suddenly, by a board-made rule, enforce something. Going back to dogs, let's say your declaration is completely silent on dogs. There's nothing about pets mentioned in the declaration or any of the government documents at all. The board suddenly can't make by rule that no pets are allowed within the community. It's a bit more complicated, so I highly recommend, if you're considering updating your rules or creating rules, that you do so with assistance of your legal counsel to make sure that you don't have any issues that might result in you being unable to enforce your rules. And just a key kind of thing to keep in mind if you're making rules is you need to make sure your declaration says something about the rule you're trying to enforce. Otherwise, you might have trouble enforcing it down the road. And that's it. Short and sweet for the most part. I'm sure there's a lot of questions because this is something that comes up for everybody.
All the time. All the time. Great job, Chris.
All the time. Again, as soon as I'm done hanging this up, or as soon as we're done this meeting, I will be writing a letter to an owner for an unapproved tenant, which is a violation of the covenants of the association. So let's hop into those questions.
You don't want to get a letter from Chris. Well, while Chris and Marielle, I don't know if Marielle may have had to skip out, and if that's the case, that's cool. But while I'm about to go over really briefly the evaluation process, I'll go over it again more slowly after Chris addresses some of the Q&A. So Chris, while I'm doing that, I'm going to go over the evaluation process right now. While I'm doing that, look over some of the questions you'd like to address. Folks, keep in mind too, everything you heard today and everything that Chris will mention as he answers a handful of some of the questions, educational in nature, informational in nature. None of this should be considered as legal advice. So please do not go to your meeting tonight and say, hey, I attended this class today with Chris and he said this, and this on slide 27. This is how it's got to be. That is not what this is about. Okay. So please, if you have any questions whatsoever, contact your association counsel. If you're happy with your association counsel, great. Don't do anything. But if you're looking for representation, I think I know a pretty darn good one and a pretty darn good firm that we're working with right now here for today's session. So give us a shout out. and give Chris a call. So Chris, take a look at some of the Q&A. I'm going to briefly go over the Q&A, the evaluation quickly now, then more slowly afterwards after you head out and start writing some of your letters. So folks, in the chat area, we placed the evaluation link. Now, the chat area is not to be confused with the Q&A where you've been typing your questions. So if you haven't already done so, press the chat button right now so it appears, and disregard that it says chat is disabled. That just means you can't send stuff to us, but we can send stuff to you. So press it right now if you haven't already done so. I just placed the link in there once again. When you click on that link, it's going to take you to this page here. This is what you go ahead and fill out. The field to fill out the information is beneath the field name. So some of the confusion that, or some of the unsuccessful submissions that I see are folks trying to enter a city name in the zip code field. The zip code field is only going to take numbers, okay? So that's where some of the errors occur. Also, some of the errors occur when your email addresses don't match. So be sure that they match. It'll say underneath if it doesn't. After you hit the submit button, you get a confirmation screen that looks like this. One of the bullet points includes downloading today's slides, which many of you asked about earlier. So after you fill out this evaluation and hit submit, you get this confirmation screen with KBR's website, contact information, ACE's website, but bullet number 2, download the slides, click on the word here, your slides open up, and then you can either right click and hit save as or print, or depending on your browser, download them or print them. But again, no two browsers are alike. You'll have to figure that part out for yourself. I'll go over that much more slowly after the Q&A. Chris, have you found a few you want to address?
I have. So just to be clear, I'm only going to be answering questions about covenant enforcement.
Right.
And if I see a question that's a bit too fact specific, I'm going to recommend that you speak with your own legal counsel. So I'm going to go down them. Bonnie asked, can the board pass a rule giving the ARC the right to grant variances to the approved color book? They can. However, you can't just grant one person that variance unless there's a specific hardship in that case. You need to be careful, because if you allow one person to do something without a good backing, you need to allow everybody else to do it, or you run the risk of potentially not being able to enforce anything at all. Gail asks, one owner has confronted several owners saying, oh, they are impacting your internet, but Comcast/AT&T have found no issues. Is this an owner or to owner issue, or should the board take action under nuisance rule? It's not really the association's job to police internet usage or internet availability. This is probably something that maybe just asking the owner for actual proof, and if they have nothing, then you move on. This enforcement violation can be emailed as well, not just mailing. The only time these violation notices can be emailed is if an owner has consented in writing to receive notices by email or electronic notice. If they haven't done that, even if you've communicated with them by email in the past, you need to make sure it is properly mailed or hand delivered.
And Chris, I'm going to interject as the firm's nerd that I am when it comes to technology. Your previous question that you answered, when it comes to receiving official association emails and stuff, when you opt in, it is up to the owner to make sure that you're keeping tabs on your spam folders, your junk folders, any kinds of filters that may hinder the receipt of said emails, even if you opted in. It is not the responsibility of the association. It is not the responsibility of the board. It is your responsibility, if you opt in, to make sure that you're able to receive them. Am I correct? Remember, I don't have that ESQ after my name, so I need to make sure
Yes,
that...
you got it.
All right. Back to you, sir.
So Susan asked, what can we do if the board didn't enforce a violation on one property and others begin violating the same rule? This is a common issue. Again, this is the thing where if you're not enforcing uniformly and timely, you might lose your right to enforce. So if this is something I would recommend talking with your legal counsel about the actual facts, but at the end of the day, if you feel like you have lost your right to enforce something, you can do something known as, the term escapes me. You basically revive your rules. So what you would do is at a board meeting, you basically inform the community, hey, we have this rule that we haven't been enforcing. As of the date, this date of this meeting, or within 30 days, we will be enforcing regularly. And then you send a notice to the community saying, hey, we've revived this provision. Be advised that after this date, we will enforce. So again, if you feel like there's a potential that you can't enforce something, speak with your legal counsel and give them the facts. Stephanie asks, can the association or management company charge a fee to send out a compliance-related letter over and above standard postage and cost of materials? They really shouldn't consider it a cost of doing business. Obviously, if we have attorneys involved and we're past the fining portion, the attorney might be able to charge those costs, but check your docs and talk with your attorney. Fining HOA documents are silent. Oh, wait, I missed one. James, what can the owner do when the board doesn't handle their responsibilities to include statute requirements? Not really covenant enforcement. So this is the kind of thing where I would suggest you get your own attorney and maybe consult the division and the UBPR and file a complaint. Joanne asks, finding HOA documents are silent. No Kaufman language in documents. Can we still find? Kaufman language. I didn't really go into Kaufman language because honestly, you could talk about maybe for a couple hours on it. So I'm not going to really address it here, but it does not matter if you have Kaufman language or even finding rights in your documents. Under the statute, you can find. We have a unit owner operating. We believe our church services in their unit have bass so loud the walls shake. All the unit owners work nights and during early afternoon are sleeping and awaken. A unit owner operating the church service goes outside yelling loudly Bible verses. While I can respect the passion, I don't respect the nuisance. This is a easy nuisance violation. I highly suggest you have your management company or board, or if I'm unable to do that, have your attorney send a notice. What if a violation occurs, then stops for months, but occurs again and again with breaks in between? Ultimately, if it doesn't stop indefinitely, it's still occurring, proceed with enforcement.
Yeah, that kind of question shows up in different forms throughout the Q&A. You're going to notice that as you go forward. About what about repeat offenders? Like somebody, you fine them for parking illegally, you fine them, then they do it again 3 months later, or they constantly do it. You're going to see a common.
Right. So for repeated violations, it's one of those things where in like any violation, you need to document it completely. So keep track of the dates it happened, and once you have enough occurring, even if they're not doing it in the moment. So let's say this person's been illegally parking for a while. March 3rd, they parked in the loading dock. April 1st, they did this. I still recommend sending the informal notice, but if they keep doing it and you've logged maybe like 5 times in 2 months, well, then you proceed with fining.
Okay, we have time for a few more, so if you want to skip around, we can do that.
Hurricane shutters is not really what I'm talking about here today. So Valerie, again, this is a Kaufman thing. I suggest you speak to your attorney. So George, does the finding/grievance committee have to exist before the board can levy the fine? I would think so, or else if it is picked after the board imposes the fine, there is less chance for it to be fair. Honestly, it doesn't really matter when it existed. The main thing that matters is that it does exist. So the board can say at a board meeting, oh, we want to proceed with a fine, but that fine cannot be added to the ledger until it is discovered or discussed, / approved or rejected in front of the grievance committee. So I don't recommend the board start levying fines at meetings until they have that committee set up, because you're not really accomplishing anything at that point. Lisa says, what happens if your condo refuses to state who the grievance committee is? Well, this is the kind of thing where if you're in a condo, you can do written inquiries and ask who's on the committee. This is the kind of information that should be presented to the members. And you're going to be talking to these people anyway at the grievance committee hearing, so you'll be able to find out who they are once you're actually at the committee hearing. I think we have time for maybe a few more.
Yeah.
How do we handle members that are appointed to the grievance committee that are also the ones that are constantly notifying management of violations people have? Is that a conflict? Honestly, probably the best people to handle those violations, because they're the ones who see them happening. I know there might be seen as like a fairness issue, but again, if you have issues with who's on the committee, bring it up with your board. But for the most part, those who are more active in the violation process, those who are actually keeping track of things, I think that they're the best ones to ensure compliance. Because if you know that the people on the committee are the ones who are seeing things, you might think twice about leaving that chair swing out in your front yard. Nicholas asks, if the community is not able to get 3 volunteers to serve on the grievance committee, can these be filled by a paid consultant to complete the panel of 3 in order for fines to be enforceable? No, you cannot. They need to be residents of the community. It's unfortunately an unpaid position. If you can't get these 3 members together, which again happens in a lot of communities, speak with your attorney and see how you can better enforce going forward. Brian, not really what we're dealing with. Let's see.
George's other question is very interesting, especially in a day and age where people own more than one unit. If a person owns, say, 2 units, unit A and B, they are behind on unit A, but they're up to date with unit B. I can see how to suspend voting rights for unit A, but how do you suspend use rights, say for the pool or the gym or entry into the convenient gate arm entryway or something like that?
The use rights are tied. I mean, obviously, I don't know how the committee is set up, but that's
Yeah.
tied to the person.
Right.
So even if they have multiple units, you suspend the use rights. Well, George, I don't care if you own 6 units in this community, you can't go to the gym. Evelyn asked, my HOA is 12 units, of which 11 are directors. Crazy. Can my HOA go to another HOA not associated to mine to request 3 of their members to be the finance committee? Evelyn, you might be out of luck. I don't think you have any situation where you can have a grievance committee if 11 of 12 are directors. You can't have a 1-person committee. You're going to need to go to your attorney to have enforcement actually have teeth. So we're almost 12 o'clock. So Carmen, I already answered this, but again, Kaufman language does not matter when it comes to fining. The statute gives those rights to the associations regardless of Kaufman or when the documents were recorded. I answered repeat questions. If an HOA owner has left holiday lights installed since moving in several years ago, are they grandfathered in / if and when the holiday deadline is added to the CCR? If something's been there for years, I would be very hesitant to say proceed with enforcement. It almost seems at this point that I would say they'd be grandfathered in. But again, I would talk to your own counsel and get their perspective.
Chris, I think that's one of those vague things out there because there are so many dang holidays right now. So what's to stop somebody from calling Christmas lights Festivus lights or what? I mean, I'm making that up, but you know what I'm saying? That I think that your documents need to be really specific. That's a good topic for updating your governing documents, wouldn't you say?
For sure, for sure. So again, with holiday lights, if someone's keeping them up, your first step is to send a notice saying, hey, so let's say your rules say can only be up for a week. You have to send that notice saying, hey, it's been more than a week. We're giving you another a week or so to take them down. If you don't, we will proceed with enforcement. Let me ask one more question.
Sure.
Fines cannot become liens, but are unpaid dues. That's about assessments. Assessments can become liens, but again, talk with your legal counsel for that process. And I guess the last one I'll do is Pamela says, can you collect the fine at time of closing, adding it to the estoppel? For the most part, unless your docs allow you to turn it into a lien, that is when you'll collect those fines. So you should make sure if fines are on the ledger that they are listed on the estoppel so you can make sure they are paid at the time of closing. So I think we're a little over 12 o'clock here. So I guess we are done for now. If you have any other questions, obviously you can reach out to our office.
You did wonderfully. It was great to work with you for my first time with you on a Zoom. You did fantastically. Hope to do it again with you, either with AS or with the firm, of course. And Chris, before you head out, and folks, if you did your evaluation, you're free to go. You fulfilled your required part. I am going to remain on, and I'll enable the chat so you could ask me technical questions in just a moment. But before I do that, Chris, any parting words on the best way for people to reach you?
So obviously the best way to reach me, and I wish I noticed the background behind me was flipped, but obviously you can contact our office. You can send an email to info@kbrlegal.com with any further questions. Obviously you can look me up on the website and reach out to me that way as well. Everybody at the firm here is quite knowledgeable about association matters, and regardless of what we do here, we all pretty much deal with covenant enforcement in one way or another. So there is certainly someone here who can address your questions. So please feel free to reach out to that info@kbrlegal.com email or give our office a call. Our number is 954-928-0680. And you can ask to speak to me. Again, my name is Chris Posner. And I hope this information was helpful. Obviously, for the more complex or fact-specific things, I urge you to speak to your legal counsel. And if you don't like your legal counsel, well, I'm a bit biased, but I know a firm that can help you out.